First of all, let me thank those three wonderful people, Director General, she just left, Secretary General, for the welcoming words. In a way, we started already. In those welcoming words, I heard a lot about reinvigorating the United Nations, the purpose of this conference. We decided to start with two dialogues, as we put it, so to make it as lively and as possible, to have a real discussion. And we're going to start this, what we call on the program, a dialogue on reinvigorating the United Nations. And there you see a little bit of a bias by Slavomir Redo and me, that is basically thinking about human rights, taking human rights seriously, and in that way, reinvigorating the United Nations. So if you want to put it that way, that's our angle. And I'm really delighted to welcome actually two fantastic people to talk on this topic. To the left of mine is Piotr Hofmański, who is the president of the International Criminal Court, and I think he well deserves a big round of applause for coming to Vienna. You'll get an even bigger one after the talk, you'll see. And then there would have been another fantastic person here to my right. There would have been Volker Türk. He's the United Nations High Commissioner for Human Rights. Those of you who are reading the news regularly, he's touring Latin America at the moment, but we taped an interview with him that I've done. So in terms of our proceedings now for the first dialogue, I'm going to give the words to President Hofmański. He's going to talk for about 12 minutes. Then we're going to discuss a little bit. I'm always going to invite questions from the floor as well. And then we're going to look at the video that we've recorded earlier.
Thank you very much, Mr. Chair. Excellencies, distinguished guests, let me thank for the invitation to take part in this prominent conference. I am honored to be here and very pleased to have a chance to speak. I am certain that I was invited here in full knowledge that the International Criminal Court, which I have the honor to lead, is not the part of the United Nations. But as the goals and values of the ICC are aligned with those of the UN, we can very well discuss them in the same context as part of the bigger picture. To be compatible with the remarks of Mr. High Commissioner, later, I would mention that protection and promotion of human rights is obviously among the most prominent tasks of the international community and the United Nations, possibly the most important task. There are obviously many different ways to protect human rights. It is a wide and deep and never-ending work. The point I want to make is this. The International Criminal Court is an integral part of the international multilateral architecture for the protection of human rights. More than that, the ICC is a unique part of that international architecture with an essential role that no other institution has. As such, the ICC plays a crucial part in the global system for human rights protection. That role is the protection of victims of the most serious, massive atrocities, such typically those occurring during the armed conflict, is genocide, crimes against humanity, war crimes, obviously also crime of aggression. The ICC provides victims with access to justice when they cannot obtain justice in the domestic courts. We can hold perpetrators accountable when national authorities fail to prosecute them. And the ICC provides victims with reparations, redressing the harm caused by the crimes against them. As such, the ICC metes out restorative justice as well as retribution. And the ICC reduces future crimes through deterrence effect. By showing that the accountability is a real possibility, the ICC puts potential human rights violators on notice that they cannot count on impunity. And why the ICC is not part of the United Nations, like I said, it might as well be. The ICC was created with the assistance of the UN and under the auspices of the United Nations. In some ways, the adoption of the ICC founding treaty, it's the Rome Statute, in 1990, was one of the most prominent moments of reinvigorating the international system in the last 50 years. Some call it the most important moment in international law since the creation of the United Nations. Why was the creation of the ICC such an important moment? One of the answers lies in the legal power of the court to oblige its states parties to arrest any person of their territory, even the highest ranking officials of the state itself. In other words, the ICC is a court with, I would say, real teeth. There is no other international institution with any kind of power even closely similar to that. Even then, the sharpness of the ICC state is relative. The court has no police force of its own. We depend on the cooperation of states for the execution of arrest warrants, for access to evidence, for enforcement of sentences, for protection of witnesses, and so on. But even with those limitations to enforcement, the legal powers of the ICC is entirely unprecedented and revolutionary, particularly taking into account this is a permanent institution. So, essentially, I would argue that the ICC is a major result of reinvigorating the international system. The reinvigorating happened during the 90s, the decade of newly found openness to collaboration on the world stage, decade of renewed faith in the power of international law. After being set up in 2002, the court has gone through a lot in its first 20 years. The court has survived many difficult moments, even outreach attacks on the institution, but it was survived and shown time and again that there is a real calling for it. It is a real need for such an institution. As such, the ICC does not need reinvigorating, especially as the court is extremely busy today with its hands full of work. The ICC has opened investigation in total 16 countries since being set up on 4 different continents. 31 cases have been brought before the court involving 51 suspects accused. You may think that it is maybe not too much, but remember that any of these cases may involve thousands of victims. The participation of each victim is recorded individually in the court records, and each one can request reparation. That, again, underlines the human rights aspects of what the ICC does. Now, I said the ICC does not need reinvigorating, but that does not mean the international criminal justice system cannot be strengthened. Of course, more can be done. For instance, the ICC arrest warrants are outstanding. Many of these relate to alleged crimes referred to us by the UN Security Council, and we hope the Council would do more to ensure compliance with the concerned state, such, for example, Sudan. The ICC Trust Fund for Victims needs more financial support so that we can deliver reparative justice to those who have suffered harm as a result of serious human rights violations taking the form of crimes under international law. More countries should join the Rome Statute of the ICC. We have 123 state parties, which is remarkable, I think. For instance, more African states have accepted the jurisdiction of the ICC than the jurisdiction of the African Court of Human and People's Rights. The entire South American continent has joined the ICC system, and almost all of Europe. Nevertheless, there are gaps, particularly in Asia, and we constantly work on attracting more states to join. But you cannot force a sovereign decision, obviously. Finally, beyond the ICC, there is a serious need to strengthen the national jurisdictions. You see, the ICC is about much more than its own investigation and trials. It's actually a court of the last resort, which by its very existence encourages and pushes national authorities to take action against impunity. The mechanism is not quite the same as with regional human rights courts, for example, but not entirely different either. The similarity lies in the fact that there is a higher impetus for governments and the domestic justice system to take action if they are aware that there is an international institution that may intervene if they don't what is expected of them in terms of upholding international law. Just about to finish, Colombia is often cited as a good example of such dynamics in the context of the ICC. The expression positive complementarity is frequently used to describe this. For more than 10 years, the prosecutor office was conducting a so-called preliminary examination following and analyzing Colombia's national justice efforts relating to the many alleged crimes in the country's internal armed conflict. Ultimately, the prosecutor closed the preliminary examination, having concluded that complementarity is working. And the Colombia is taking serious and ingenious efforts to investigate and prosecute Rome Statute crimes. And even when the ICC does not open investigation cases, positive complementarity is still needed to allow the ICC to hand over the task of justice to the international authorities at some point. This is what we have seen in the Central African Republic. The ICC opened several cases in the Central African Republic, and actually 2 of our 4 current trials concern the alleged crimes in that country. But the ICC can only answer process of fraction of the perpetrators and the selection of the gravest crimes. This is why we find it very positive that the core authorities, with the backing of the United Nations, many different states, have established a special court in Bangui, which can complement and continue the work of the International Criminal Court. With this realization, the ICC prosecutor recently announced that he would not pursue any new investigation in that country, while the ICC will, of course, remain fully engaged in the context of ongoing cases, as well as, obviously, reparation provided by the Trust Fund for Victims. But I think I have already used my time. If you have a question, Mr. Kornprobst.
Yes. No, thanks a lot. Thanks a lot for your talk. No, thanks a lot for your talk, which confirmed to me that it's actually important to start talking about human rights when one talks about reinvigorating the United Nations. Out of curiosity, from a political science point of view, not a lawyer, when you look back 20 years of ICC, are there particular kinds of conflicts? Are there particular kinds of crime where you would say the ICC does better? And would you say that there are particular conflicts, particular crimes where the ICC struggles more to do its work?
It is not easy question. It's not easy question. Obviously, our scope of jurisdiction is limited. As you know, we don't have the terrorism, international terrorism, even if many expect us just to prosecute also the terrorist acts. We don't have the protection of the cultural heritage, for example, or the natural environment in our statute. But still, what we try to do is just to use the opportunity, as maybe it's not the good explanation, just to treat, for example, some terrorist acts or also action against the cultural property as a part of the crimes under the Rome Statute. It happens, for example, in Mali, where we have also already the conviction for the destroying of the cultural properties in Timbuktu, which is not literally provided in the statute. And it is the same process with the Terrorists Act, because sometimes these acts can be treated as the elements of crimes against humanity, which take place, for example, in many prosecutions already, but especially in Congo.
Mm-hmm. Mm-hmm. There's related to that perhaps another question, and I'll leave it, and then I'll open up the floor. What about the cooperation of member states? So overall, how satisfied are you with the cooperation of member states? Because you mentioned some states in the Horn of Africa, I think, in your statement, where things obviously were quite difficult, but overall, how satisfied are you with that?
No, the cooperation with the ICC is the obligation of state provided for in the statute. It is the legal obligation to cooperate fully on the state, what the statute says. And more or less, the states do it, that are involved, with the one exception, unfortunately, very crucial exception, means we have a lot of outstanding arrest warrants. Mm-hmm. And the first obligation of the state is to arrest the person under the arrest warrant on its territory, and it not always up. It's mm-hmm. true. But we have also the voluntary form of cooperation related to the enforcement of sentences, for example, related to the protection of witnesses, related to the relocation of witnesses, and then we try to build the network of states who are ready to help the ICC in the realization of its mandate, and it is sometimes difficult. It is a relatively good situation in Europe. The many European states are involved. But for example, in Africa, where we have a lot of accused person and also convicted person, I think we have only Mali, which is ready to cooperate in the enforcement of sentences. So even if we convict someone, it is very difficult to find the state where the penalty, the deprivation of liberty can be enforced. And we don't have it, our own facilities. We have only the arrest facilities for the time of the proceedings. It's complicated. And if you talk in cooperation, let me also say 2 words in the context of the UN. I think, the referral of the UN is not the matter of cooperation itself, but the cooperation should follow. If the UN Security Council refer the situation to the ICC, what happens in case in Libya and Sudan, Darfur, we would expect that the Security Council would help. And it is unfortunately, I cannot say not the case, but this support is limited. It's not satisfactory.
It's called the Diplomatic Academy. It was a very diplomatic answer, but but I think a very convincing one. Let me open up the floor, and I anticipate quite a few questions. Yeah, so I'm gonna bundle at least 3 at a time, and we have someone to take care, Moges, to take care of the microphone, and maybe we're going to start in the back. Yes. And please quickly introduce yourself and ask a brief question so that we can accommodate quite a few for the questions and answer session.
First of all, thank you very much for your convincing speech. My name is Benedikt Höfter. I'm a second-year student in the Master of Advanced International Studies here at the Academy. My question is quite simple. Do you think it is important for the future of for the stability of the international system to expand the jurisdiction of the criminal court? Thank you.
Thank you. And then we had, I think, Corvinian, and then we're gonna.
Thank you very much. My name is Corvinian Bayan. I'm also a MICE 2 student here at the Diplomatic Academy. And my question is the international system equipped to handle with international crimes committed by one of the permanent members of the Security Council, which is not part of the Rome Statute? Thank you.
That's a good question. And then we have the gentleman, Moges, gentleman there in the front, yes.
Thank you. My name is Klaus Bachmann. I'm a political science professor from Warsaw and tomorrow in the program. There are several proposals out there about a hybrid tribunal or an UN tribunal created by the United Nations General Assembly to overcome the jurisdictional obstacles at the ICC with the crime of aggression. Do you have a preference for one of them? And do you think that it would affect the position and the functioning of the ICC if one of these proposals entered into force?
Thank you. And we can have two more questions, so if you want to. Maybe this side I've neglected thus far, otherwise we're just going to move on. Okay, good.
It's already enough.
That's more than enough, actually, you're right.
So, I will start with the rather simple question related to expansion of the jurisdiction. And what I should say, that is obviously not for the court, but it's for the state parties and the Assembly of State Parties, which is the legislative body of the system, to decide about the scope of this jurisdiction. Judges will simply apply the law. But of course, I'm aware of the discussions about this issue, and I would like to mention this. The court is, we are 18 judges. Of course, there's a lot of supporting staff. True, there's also other, we are active, as I said, on many continents already. But we are basically on the borders of our capacity. And if it comes to the new crimes, we would need to reform the whole system. Within existing system, I don't think it would be possible to expand the jurisdiction beyond what we already have. But as you may know, there is a discussion about the ecocide. It's a very advanced discussion about it. There is a discussion about the international terrorism. Of course, we will apply the law as established, but I hope the decision will be really followed by further decision related to organization of the court and to the restructurization of the whole system. This is one. The question of the scope of the jurisdiction, especially in respect to the crime allegedly committed on the territory of Ukraine. Well, the legal situation is simple. We have the jurisdiction in respect to 3 of 4 core crimes of the Rome Statute, means in respect to the crimes against humanity, the genocide, and war crimes. Also in respect to all crimes committed on the territory of Ukraine, and it's based on the declaration of the Ukraine launched in 2014. But this declaration does not cover the crime of aggression. It is because the state parties in the Kampala in 2010, there was the amendment to the RAUN statute decided, they created a very complicated mechanism to trigger the jurisdiction over the crimes of aggression, which is, in my personal opinion, a little bit not realistic, because it requires that both states, the aggressor and the victim of the aggression, must ratify the amendment to the Rome Statute to accept the jurisdiction of the crime of aggression. And additionally, there's the decision of the Security Council needed to determine whether the act committed is the crime of aggression or not. You see, especially in the situation where the aggressor is one of the permanent members of the Security Council, it is completely not realistic to expect that this could happen. And therefore, there is a problem with the scope of the jurisdiction with respect to this situation. And I will shortly go to the third and last question asked, which is linked to the possibility to create the new tribunal, the new body dealing only with this one aspect, means crime aggression, bearing in mind that it is the gap of the ICC's jurisdiction. And so, sorry, I must a little bit disappoint you, Professor, asking the question, because, you know, it is not for me to answer this question. It is the political decision. I am not a politician. I am a judge. I'm the president of the court, and we will apply law as established. And therefore, it's for state to decide what to do. What I can discuss with the partners is the practical consequences of this step, and I see that it will not be easy, especially it would comes to the charges against the same persons. But it is basically everything what I can say, leaving this issue to politicians.
Thank you very much. And then we're going to move on now to the imaginary virtual Volker Türk, who you're going to see to the left and to the right. It's an interview that I did with him about 2 weeks ago. Mr. High Commissioner, thank you very much for this interview. And as a way of starting, there's oftentimes this narrative about human rights that they gain somehow momentum during the détente, during the Cold War. And then the 1990s were the heydays, and afterwards things became much more troublesome in intrastate affairs, but also in terms of interstate affairs when we look at Russia and Ukraine at the moment. What do you think about that narrative?
Well, I think we are at a very difficult moment when it comes to human rights, because first of all, we have seen a number of pushbacks and backsliding when it comes to gender issues, women's issues. I mean, things that frankly were taken for granted seem to be questioned also in the global north. I mean, just look at sexual and reproductive health rights. But then you have the other extreme, of course, is Afghanistan, where you have an unparalleled repression of women's rights. So. But then you also have seen, so this pushback is also in relation to civic space, for example, the expression of freedom of expression, freedom of assembly, basic freedoms of participation and political participation, that the freedom of journalism, I mean, everything around media, independent media and responsible media is again, you see a lot of journalists who are being either arrested or intimidated or can't do their work. And this pushback is happening at a time when we see a lot of geopolitical divisions and tensions. And if you throw human rights into this, when you have a very fragmented world, it's becoming very contentious. So what, in fact, human rights almost are associated with contentious issues. They're associated with doom and gloom, and it's really important, especially this year when we celebrate the 75th anniversary of the Universal Declaration of Human Rights, that we regain the force that human rights represents when it comes to universality, but also indivisibility. And I think that's an important point, because there's this artificial distinction between civil and political rights and economic, social, and cultural rights. And we have to see it as a whole spectrum of human rights that is not one against the other, or one at the expense of the other. They have to be seen as a continuum. And I think that's really important to regain that space. And I'm glad that you also in the academic sphere are dealing with it, because we need to find ways and means to debunk some of the myths around human rights that have emerged over the last couple of decades.
And when it comes to this continuum, do you see some kind of a convergence of state positions on the horizon? Or do you think it's going to stay very contentious?
I mean, so I took over my own functions about 2.5 months ago. And it's interesting because I keep raising the issue of universality and indivisibility. And in the responses, I mean, the response is often, well, you know, let's work on it. I think there is a realization that we cannot just have the world divided into different silos on the human rights front. But it's going to be a very tough conversation to have. But I mean, for instance, right to life is so much, you cannot disassociate it from the right to development. And you cannot, when it comes to health, for example, and education, you are not, which is economic and social rights, you can, or social protection schemes, for example, which social justice issues, you cannot disassociate them from civil and political rights either. So you see the fact that they are all interdependent and one is related to the other and they are interlinked is a realization that only comes when you actually look at the world, at reality, at what societies are going through, either in peace or in conflict times, and you actually realize that, you know, the human rights regime as such is incredibly interlinked. And so it's going to be important to build on it and to counter some of the, frankly, I would say, myths or propaganda that we have seen around human rights, you know, where, you know, people say, well, this has got nothing to do with the human rights regime as we know it. No, and in fact, no, we just have to argue it and say, sorry, that's not correct. I mean, and it's interesting because the Universal Declaration of Human Rights covered all segments. I mean, it covered civil, political, economic, and social rights. It was very clear. And Eleanor Roosevelt, who, as you know, was the chair of the commission, had huge fights also within her own delegation about this, but she managed to ensure, and not least given the 4 freedoms that her husband had proclaimed, which included freedom from fear and freedom from want, she managed to convince also her own delegation that, you know, economic and social rights have to be part of the equation.
Yeah, and that's an important point. Yeah, and also convinced other delegations probably.
Yes.
Which leads me to my next question. I think you hinted at it already. To some extent, we need a working multilateralism, a strong multilateralism, in order to do something about human rights. What prospects do you see there? Because we obviously find a lot of criticism against multilateralism at the moment. We find almost amongst the academic community some kind of a despair in terms of multilateral diplomacy. What ways forward do you see there?
On the human rights front, well, first of all, I mean, it is clear that human rights, in order to make sure that they are implemented, they need to be realized at the national level. I mean, there's no way around it. And I mean, the more there is awareness, the more, for instance, in legal and political arenas at the domestic level, I mean, you know, Austrian lawyers are studying also human rights law, the more we actually will see that their own interpretation of the law is going to be influenced by these international legal matters that human rights law represents. And that's the same for, you know, most lawyers who work in a domestic context, the same for those who work in politics or as diplomats. I mean, it is important to have not just a basic knowledge, but an in-depth knowledge of human rights law, so that we're able to actually make sure that it's understood. Then there is the regional context. I mean, in Europe, we have the advantage with the European Convention on Human Rights, of a very robust legal system that has teeth. And when you talk about multilateralism, well, there is multilateralism with teeth, and the European Convention and the court is a good example of that. We don't have the same privilege in other parts of the world. I mean, you don't have you have only in the ASEAN context a regional mechanism on human rights, but it has no teeth. And you do not cover the Asia-Pacific region through a similar system. We have in Africa, yes, in Africa you have a regional system. But again, sometimes the question of implementation is an issue, and you have in the Latin American system with Inter-American Commission and the Court of Human Rights, you have again the possibility of judgments. So these are good. This actually shows that when you are not able, and when you've exhausted the domestic remedies, you can go to a regional court, or you go to the human rights bodies, treaty bodies at the UN level here in Geneva, and you can have recourse to that. And as a result, there are then discussions with member states about the implementation of it. But as you know very well, part of the problem is always, and that goes to how effective member states would like the multilateral system to work. It has to have some teeth. And if the teeth aren't there, then it's going to be difficult. And on the human rights front, there are many tools that we have. I mean, we have, apart from these regional mechanisms, the national and the regional mechanisms, we have the global mechanisms, and we have the treaty bodies. They are very important. They play a certain role. Their decisions are not necessarily binding, but they have a very strong force of, even I would say, a legal force, apart from the moral one, because they need to be taken into account in decisions. Then, of course, you have the different mechanisms: the Human Rights Council, the Universal Periodic Review, and the special procedure mandate holders. And there it's because of public pressure, it's because of even being considered within the Human Rights Council, which is a member state-driven body. It does have an impact. It could have preventative effect. And also, as when I started, I noticed that a lot of, well, very senior government officials have reached out because they don't want their country to appear anywhere close to an area where they could potentially be criticized. And so there is, if you like, also the public pressure that actually helps us. But they are not binding teeth that one would want to have in some of these instances. And I think that's still quite a bit of work to be done to make it more effective. But the other thing, and maybe I should mention that, is also business and human rights, because we have member states as actors, but we have also other actors. We have businesses, enterprises, the private sector as an important actor. And there we have seen a huge, over the last 10 years or so, with the guiding principles, the UN guiding principles on business and human rights, seen a huge area of behavioral change as a result of that. And of course, businesses, and especially big businesses, multinational companies and so forth, there are human rights implications of what they do, and that's important to bear in mind as well.
The conference that we are organizing is entitled Reinvigorating the United Nations. And if one looks, say, at the UN Charter, then obviously there's a lot about sovereignty. You mentioned beforehand the Universal Declaration of Human Rights. And of course, there are lots of human rights instruments by now. But what would you say, what is the role of human rights for reinvigorating the United Nations? How important should human rights be for that?
I mean, importantly, when one of the previous Secretary General, Kofi Annan, when he published his report, In Larger Freedom, he actually used this phrase from the Charter of the UN, and then it led to it led to the whole outcome document that came out of this process, including the realization that the UN as such is built on 3 pillars: peace and security, development, sustainable development, and human rights. So I think it was the first, that was in 2005, it was the first time that there was a proper recognition that the 3 foundations upon which the UN is built, one of them is human rights, which perhaps in the past was not as apparent, I would say. Let's not forget, and it goes back to Vienna. 30 years ago with the World Conference on Human Rights, which took place in Vienna, with the Vienna Declaration and Program of Action on Human Rights that came out of this World Conference, it gave birth to the institution that I represent, to the High Commissioner for Human Rights, to the Office of the High Commissioner. And in a way, it was also a tool to make human rights more effective, because it allowed the idea of a senior UN official whose job it is to promote and protect human rights all over the world, and to do it both through advocacy but also through quiet diplomacy. I mean, you have this sometimes contradictory mandate that was given, but it's a very powerful mandate, and obviously it's one that is important to not just implement at the Geneva and New York level, but also in offices around the world, which is what we're doing. We have many more offices than ever before around the world, and that often the work is done there. But on your more general question, I think if you look at the Charter and some of the arguments that we hear about domestic interference in interference in domestic affairs, or national sovereignty arguments that are used when it comes to human rights issues, the Charter is very clear. The Charter talks about, both in the preamble but also in a number of Article 2, a couple of other articles, about the promotion for the respect, the protection and the promotion for the respect of human rights and fundamental freedoms. So the Charter, the purposes, the principles and purposes of the Charter make it clear that human rights is part and parcel of what the UN is about. And so you cannot say that when it comes to human rights issues, that this is an internal matter and it's an interference in domestic affairs. So again, these are the old myths that sometimes get regurgitated, but frankly, we need to counter that very, very strongly, including from an academic perspective.
Mr. High Commissioner, thank you very much. And since we will have you at the beginning of the conference together with the president of the ICC, you see our biases as well. So we basically start from a human rights perspective, and then look at other fields like security and development and justice and so on. Yeah, thank you very, very much.
Great, thank you.
Yeah, so thank you very, very much for our 2 speakers, Judge President Hofmański and Volker Türk, the United Nations High Commissioner for Human Rights. I'm going to hand over now to Mona Khalil from Mac Law International, also affiliated with the Harvard Law School. And she is going to be the facilitator for the next dialogue, which is a dialogue on key principles of United Nations Charter in today's world.